If you're planning to sponsor your spouse, or your marriage-based green card is already filed, you need to hear this before your next upload notification distracts you, because the government is quietly tightening how these cases get screened, and the people who get hit first are the ones who assume our marriage is real, so we're fine. This is the moment where a missing document, one inconsistent address, or one careless answer can flip your case from normal processing into months of delay, a sudden interview, or a denial you never saw coming. And here's the scary part. You often won't know you triggered a problem until the notice shows up, your interview gets scheduled, or your file goes into a black hole additional review phase that can separate families for a very long time. So if you're waiting for an interview, waiting for a consulate appointment, waiting on a request for evidence, or even just thinking about getting married and filing soon, don't skip this, because the decisions being made right now can ripple across thousands of pending marriage cases without any dramatic headline announcing it. USCIS has openly said it's updating and consolidating policy guidance to enhance capability to screen and vet family-based immigrant petitions. And that language is not just bureaucratic fluff. When an agency updates guidance around eligibility, documentation, interviews, and decisions, it changes the vibe of adjudications in real life, at your kitchen table with your evidence packet, and at that interview window where one officer's doubts can set your timeline on fire source. What does that mean for you in practical terms? It means your case is less likely to be treated like a routine checkbox exercise and more likely to be treated like an investigation into whether your relationship is legally valid, provable, and consistent across every single piece of paper and every digital footprint USCIS can compare. USCIS policy is crystal clear that for spousal immigration, they're looking at whether the marriage is legally valid where it happened, whether it's consistent with U.S. public policy, whether it was bona fide, entered in good faith, and whether you were both legally free to marry. And that bona fide part is where most people emotionally assume they're safe and then get blindsided, because officers don't just want a wedding photo and a certificate. They want a life that looks merged in a way that makes sense for your culture, your finances, your living situation, and your timeline source. And before you tell yourself, but we're long distance, we can't do joint bills, listen carefully. Long-distance marriages can absolutely be genuine, but they're also the exact type of file that can get extra scrutiny, because it's easier for an officer to wonder whether the relationship is more on paper than in real life. So you have to over-explain what a normal married life looks like for you right now and how you're building toward living together. Because if you leave gaps, the officer fills those gaps with suspicion. This is what immigration officers won't openly tell you. A lot of red flags aren't moral judgments. They're pattern recognition. Big age gaps, very short courtships, inconsistent timelines, not knowing each other's daily routines, mismatched addresses, no shared financial story, prior filings for other spouses, or prior withdrawals. These aren't automatic denials, but they are magnets for interviews and RFEs. And once you get pulled into that lane, your case can move slower and feel colder. USCIS guidance even spells out scenarios that can trigger required interviews in spousal contexts, including certain minor age marriages, situations where a heightened evidentiary standard applies, prior spousal petitions for different beneficiaries, or adverse decisions, withdrawals tied to either spouse. Translation: your history follows you, even if your current relationship is real source. Now let's talk about the mistake that quietly destroys timelines. People think the goal is submit a lot, when the real goal is submit evidence that matches. USCIS lists examples of bona fide evidence like joint ownership of property, joint lease, commingled finances, children's birth certificates, third-party affidavits, and any other documentation relevant to showing the marriage wasn't entered to evade immigration law. But the trap is submitting a messy mountain of documents that contradict each other. Different move-in dates, different versions of your name, unexplained gaps in cohabitation, separate tax filings with no explanation, or screenshots with missing context source. One strong, consistent narrative beats 300 random pages every time. And yes, small mistakes can cost you months or years, because once USCIS issues an RFE or a notice of intent to deny, you're not just adding documents. You're now trying to rebuild credibility under a deadline, and the case may pause while they wait, then pause again while it gets requeued. Also understand this. Interviews are not just about romance. They're about verifying identity, eligibility, and risk. USCIS policy on adjustment interviews explains that applicants must be interviewed unless waived, and the waiver decision is case by case, meaning you can't plan your life around the hope that you'll probably get waived, because the file itself decides your fate based on what the record shows and what it fails to show source. The same USCIS interview guidance lists reasons an interview may be required that should make you sit up straight: confirming identity, validating status, unresolved entry issues, criminal or national security concerns that can't be cleared at a service center, fraud concerns flagged by the service center, fingerprints rejected twice, certain medical inadmissibility issues, yes answers to eligibility questions that can't be resolved by RFE, or even something as simple as the agency not being able to locate your A file or receipt file when you have multiple files. So sometimes you did nothing wrong, but your case still gets pushed into the interview lane because the system needs something it can't get on paper source. If your file is already in process and you're thinking, we're good, we already filed, this next part matters. USCIS has clarified it may require interviews for family-based petitions, and it has also clarified that a family-based petition doesn't give the beneficiary immigration status or protection from removal, and that USCIS may issue a notice to appear if the beneficiary is otherwise removable. This is not meant to scare genuine couples, but it is a reality check that the stakes are higher than approval or denial, especially if there are complications in someone's status history source. So if you're in the U.S. and adjusting status through marriage, be brutally honest with yourself. Are there old status violations, prior proceedings, prior applications with inconsistent info, or anything you're hoping won't come up? Because USCIS's posture is telling you the opposite. Assume it will come up and prepare properly. This is where most applicants fail. They treat the forms like paperwork, not sworn statements that will be compared against prior filings, entry records, and sometimes other databases. A small inconsistency, like listing one address on one form and another on another form, or saying you met in June on one document and July in your interview, can read like deception when the officer is trained to spot patterns. And once an officer thinks something is off, it's not just about romance questions anymore. It can turn into verification of every major claim in your file. Now zoom out to the part people don't budget for emotionally or financially: process cost and delay pressure. USCIS implemented a major fee schedule final rule effective April 1, 2024, requiring benefit requests postmarked on or after that date to include the updated fees. And while fees alone aren't a marriage crackdown, higher costs raise the penalty for refiling, the pain of rejections for incorrect fees, and the overall damage when a case gets bounced back for a technical problem source. That matters because a shocking number of couples still lose time to avoidable errors: wrong addition date, missing signature, incorrect payment method, incomplete supporting evidence, or submitting something that triggers an RFE you could have prevented with cleaner preparation. And if you're wondering how long is it going to take, the only honest answer is it depends on the form type, category, and the specific office, and USCIS itself emphasizes processing times are measured by how long it took to complete 80% of cases over a recent window. So your case can still be slower, especially if it gets flagged for interview, RFE, file transfer, or background check source. That's why this decision environment matters right now. When scrutiny increases, more cases get pulled from the fast lane into the slow lane, and you feel it as silence, delay, and anxiety, especially if you're separated across borders and every month changes jobs, leases, pregnancies, and family emergencies. And speaking of borders, don't ignore what's happening on the consular side either. The Department of State updated its interview waiver policy effective October 1st, 2025, narrowing who can skip in-person interviews for many non-immigrant visa categories, while also emphasizing consular officers can still require interviews case by case. This doesn't directly rewrite immigrant spouse visa rules, but it signals a broader return to in-person scrutiny post-pandemic, and it absolutely matters if you're in a marriage-related pipeline that touches non-immigrant categories like fiancé paths, travel during processing, or renewals where people assumed Dropbox would always be a available source. If you're thinking, we'll just visit each other while we wait, understand that travel decisions can become evidence decisions. Your entry history, how long you stayed, what you told border officers, what you posted online, and whether your actions match the story you're telling USCIS can all be weighed when an officer is deciding whether the marriage looks bona fide and whether anything looks like misrepresentation. Now, I want to hit a few areas that cause sudden denials or ugly delays, even in real marriages, and you need to treat this like a checklist in your head, even if I'm saying it fast. First, legal validity and free to marry. USCIS policy explains that divorce documents have to be final, not an interim decree, and that if your prior marriage wasn't actually terminated under the relevant law, your new marriage can be considered invalid for immigration purposes, even if you emotionally consider it over. So if your case involves prior marriages, this is not the place for assumptions. It's the place for certified proof source. Second, proxy and virtual marriages. USCIS states proxy marriages are only valid for immigration if the marriage was later consummated, and virtual marriages can be valid if valid, where celebrated and consistent with policy. But if you weren't physically together for the ceremony, you may still need to prove consummation after. This is one of those technical details that couples miss because they're focused on love, not legal categories, and missing it can trigger RFEs or denial source. Third, the heavy burden scenarios. USCIS describes situations involving heightened evidentiary standards and the marriage fraud bar under INA 204C, where the record must be evaluated for substantial and probative evidence of fraud and where prior history can poison future petitions. Translation: if there was a prior marriage-based issue anywhere in either spouse's history, you need professional level preparation, because "we're real" won't be enough if the file already contains damaging evidence or admission source. Fourth, the interview itself. USCIS explains the interview is where you correct errors, re-sign if changes occur, and resolve incomplete answers. And it also explains interpreter rules and the agency's discretion to disqualify an interpreter if integrity is compromised. So if you're waiting for interview, don't treat it like a casual chat. It's a sworn verification event where your credibility is being measured in real-time source. If your marriage is genuine, the goal isn't to sound perfect. It's to sound consistent, grounded, and normal. Because real couples can forget dates, but real couples usually don't contradict the core facts of their life together. Now let's talk about conditional residence, because this is where people get trapped years after they won. If you got a green card through marriage and you were married less than 2 years on the day you became a permanent resident, your status is conditional and USCIS is blunt. You must file to remove conditions, and if you don't file on time, your status automatically terminates, and USCIS can begin removal proceedings by issuing a notice to appear. This is one of the most painful surprises because couples think the stress ends at the first green card. Then suddenly they're fighting a deadline that can break families if missed source. USCIS also explains you generally file jointly with your spouse, but there are waiver options if the spouse died, divorce happened, abuse occurred, or extreme hardship applies, and they explain late filing requires a written explanation and a good cause determination. So if your marriage is struggling, or you're separating, or you're afraid your spouse won't cooperate, don't wait until the last minute and hope love fixes the paperwork. Immigration deadlines do not care about your emotional timeline source. Also note, USCIS says a properly filed I-751 receipt notice can extend status and work authorization for a long period while it's pending. But that doesn't mean you can relax, because if they schedule an interview to test your eligibility to remove conditions, you need to be ready to prove the marriage was real, and if they deny, you can end up in removal proceedings and fighting in front of an immigration judge, which is a completely different level of stress and cost source. Now, the part you've probably felt in your chest this whole time: what should I do right now if I'm in this process? If you're about to file, slow down and build a clean, consistent evidence record that matches your story. Don't just dump documents. Curate them so an officer can quickly see a real shared life. If your file is already pending, don't set it and forget it. Keep collecting ongoing proof of your relationship. Keep your addresses consistent. Keep your names consistent. And if something changes, job loss, move, separation, pregnancy, legal issues, document it and get advice before it becomes an inconsistency that looks like concealment. If you're waiting for interview, rehearse the facts like a couple who knows their life, not like actors memorizing lines. Review your forms so you don't contradict your own paperwork. And understand USCIS can interview spouses together or separately in some situations, and they can dig into anything that looks unresolved source. If you're worried about finances, don't guess. Support obligations and sponsor eligibility are not vibes. They're legal commitments, and USCIS policy even notes that anyone executing the Affidavit of Support must be at least 18 at signing. And in real life, officers look hard at whether the sponsor can actually support the immigrant without triggering problems later source. And if you're thinking, maybe we can avoid scrutiny by staying quiet, understand that silence is not strategy in a system built on verification. Clarity is strategy, consistency is strategy, and proactive organization is strategy. The emotional truth is this: marriage-based immigration is supposed to be about unity, but the process can feel like the government is trying to prove you wrong. And that's why these policy signals matter, because when agencies emphasize screening, interviews, and vetting, the margin for error shrinks, and genuine couples pay the price when they treat the process casually. So take this as your alert. If you're filing, refiling, responding to an RFE, preparing for interview, or approaching removal of conditions, assume more scrutiny, assume longer waits in some cases, and assume your smallest inconsistency can become your biggest delay. Then build your case like your family's future depends on it, because in many situations it honestly does. Educational disclaimer. This content is for general educational information only. Immigration policies and procedures can change, and you should consult official government sources and/or a qualified licensed immigration attorney or accredited representative for advice on your specific case